So a federal judge handed a big loss to the Trump administration in their efforts to get rid of the Federal Reserve Governor, Lisa Cook. And one of the really interesting things about this opinion is finally we have a federal judge who gets the standard correct in terms of analyzing the harm in the case. So let's break this down for you. But first, let me remind you and me to make sure I ask you to subscribe to our channel and just hit that subscribe button. So the court did a great job of laying out in a really comprehensive piece of legal writing the background, the standard, everything that is at stake in the case. And it's really useful to take a look at how the court describes for us the background, the statutory background of the reserve. So it was established over a century ago by Congress in the Federal Reserve Act. And it has a really unique structure. We've heard a lot about why it's independent, like many other independent agencies, but this is really independent. First of all, it's got a very complex set of relationships between the Board of Governors, the Federal Open Market Committee, and the 12 regional Federal Reserve banks. You can see in many ways this is much more complicated than just a single independent agency. And as we know, their task is, among other things, quote, promoting effectively the goals of maximum employment, stable prices, and moderate long-term interest rates. The board conducts monetary policy, regulates banking institutions, and maintains the stability of the nation's financial system. Now, when you think about that, you understand the need for the continuity of the board. You wouldn't want the governors just sort of willy-nilly being kicked off, because the whole idea of stability is to have the same people, a steady policy in place. Next, let's talk a little bit about just what makes it so independent. As the court points out, to have sound monetary policy, you have to make some short-term sacrifices for the long-term good of the economy. So that's why Congress designed the Federal Reserve and the Board of Governors to possess characteristics that insulate them from the rest of the government. So, they got a long-term there. That's one thing we'll talk about. But most importantly, they're funded outside of the annual appropriations process through bank assessments. So they're not really dependent the way other agencies are on the whole appropriations fight. Also, its decisions and deliberations on policy are exempt from the Government Accountability Office audits. And its rules regarding monetary policy are exempt from the Congressional Review Act. The board, can actually present their own legislative recommendations and testimony to Congress without approval from any other officer or agency of the U.S. Lastly, a really interesting thing to me as a prosecutor, former DOJ official, is the board also has independent litigating authority. Take a look at this example of their annual report. So what do you notice there? DOJ isn't a party. So DOJ wouldn't necessarily defend or sue on their behalf. They have their own independent litigating authority. Now let's get to the makeup of the governors, right? We've got 7 Board of Governors. Each one's appointed by the president, and they're set there for 14-year terms. That's their term that's set forth. That's the idea behind any single administration from packing the board, and further shields it from partisan influence. Now, the issue is they can be removed, quote, for cause, but nowhere in the statute is the term for cause defined. That's where this whole kind of dubious claim that Trump did, that she has committed mortgage fraud, a referral has been made, no charges have been brought, but that doesn't even matter, because what matters is the allegation of wrongdoing on her part happened before she became a governor. So therefore, while she's serving as governor, you wouldn't be able to find that there was cause to terminate her. There's nothing happening during her service there. It didn't arise at that point. Now let's get to the legal standard part. The legal standard here, it came up to the district court as a TRO, a temporary restraining order, as well as it's now being treated as a preliminary injunction, because the court points out those standards are really the same and does a nice job of reminding us of that standard. Quote, a temporary restraining order is an extraordinary remedy, one that should be granted only when the moving party, by clear showing, carries the burden of persuasion. Goes through the factors, most importantly, the irreparable harm, the substantial likelihood of success on the merits. And it's the irreparable injury, the irreparable harm that I want to focus on for a second, because finally, we have an example of a judge getting the harm analysis right here. And she points out that here, quote, losing her role at an independent agency like the Federal Reserve does not compare to other employee terminations that were not deemed irreparable, like that of a probationary employee, for example. Her removal from the board would result in missed votes and lost time that cannot be remedied by back pay or reinstatement after the fact. That's the critical point. You can't just remedy it with back pay. It's not like any other employee. There's a prestige to this. There's an importance to the role that you can't just make it up afterwards. That's exactly why, I know I sound like a broken record here, that's why you have temporary restraining orders. It's why you have preliminary injunctions. Freeze the status quo. Make sure harm doesn't happen while it gets litigated. And that's exactly what's happening here. Maybe at the end of the day, it works its way through the system, and perhaps the Supreme Court will side with Trump on this. But in the meantime, chaos isn't being sown in the monetary system. Trump isn't able to just willy-nilly quickly snap his fingers and have things happen. It gets slowed down through correct process. So kudos to this judge, Jia Cobb, former partner at a civil rights firm, a former federal public defender appointed by President Biden. We need more judges like this. We need justices like this on the Supreme Court. People, jurists who have actually represented people in a courtroom, know their way around the courtroom. We need jurists and justices who understand the impact of the law upon human beings, not institutions, and care about the harm to human beings, not the harm to some lofty concept of an institution. So happy this one came out the right way. Kudos to the lawyers who pushed this forward, and for Ms. Cook for standing up for her rights, and we'll keep an eye on it. Talk to you soon.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.